Please be seated. Thank you. Welcome to the Utah Court of Appeals. I'm Judge Ryan Harris, and with me are Judges Gregory Orm and John Luthi. We're excited to be here today and hear your arguments in these cases. The first case in front of us today is actually two cases, both captioned In re KJ. And so I guess let me take appearances from counsel, and then we'll sort of discuss how we're going to do the division of time here. Let's start with counsel for the appellants.
Good morning, Your Honors. I'm Kirsten Norman. I represent Appellant Mother. To my left is Emily Adams, who represents Appellant Father. We jointly briefed these issues, and I will be arguing for both appellants today.
Okay. Good morning to you both. Let me take appearances from the other side, and then we'll come back to you about timing.
Martha Pierce, attorney guardian ad litem for the minor children. We'll be splitting the time down the middle.
John Peterson, Assistant Attorney General for the state, and as Ms. Pierce said, half and half.
Okay, great. Good morning to both of you as well. So the question in my mind then is how much time are we splitting? Given that there are two appeals, I guess if we were going to do this by the book, Mother would get 15 minutes and Father would get 15 minutes, and then you each would get 15 minutes or you'd have a total of 30. You could split any way you wanted. But I'm given to understand that that might not be the way we want to go today. So Ms. Norman, what are your thoughts?
Correct. We have all the same issues jointly briefed, and those will be the issues we seek to address. And so we just thought that the regular 15 minutes should be sufficient for both of us. And
Okay.
I would be the only one doing oral argument.
All right, well, that's certainly fine with me. What are your thoughts over here?
I'm good with that.
Do you need the extra time, or are you fine splitting 15 minutes in light of them waiving 15 minutes?
Absent questions, I'm totally good with that.
I think
Okay.
that should be fine, Your Honor. I assume if you need more time, you'll give us more time.
Yeah, no, well, that's fair. That's a fair assumption. Wait, do you think I might have questions? Wait, what, who? Anyway, all right, well, we're glad you're here today, and we look forward to hearing your arguments. We'll plan that. So you've reserved 3 minutes, so we're going to put 12 on the clock and then have you go from there. Any other questions about the argument this morning? Okay, Ms. Norman, we look forward to hearing your argument.
Good morning, Your Honors. May it please the court. As I mentioned, I'm Kirsten Norman, and I represent appellant parents in this case. And the appellants are parents of 3 medically complex children with some very intense medical needs. And what this case is asking this court to do is determine where we're going to draw the line between behavior that we think it's appropriate for parents to engage in on behalf of their care and treatment of their children, and what we're going to start calling child abuse and neglect. And if we leave that line where the juvenile court has drawn it, we run the very real risk of including a world of behavior that safe and appropriate parents can engage in. And so we're asking this court to reverse the juvenile court's adjudication finding for the following 4 reasons. Firstly, because the juvenile court's findings do not meet the statutory definitions of harm necessary to adjudicate the parents for abuse. Secondly, because the juvenile court's conclusions as to neglect were erroneous and did not meet the clear weight of the evidence. Thirdly, because the juvenile court misapplied the shelter statute by failing to make a reasonable efforts determination on the record. And fourth, because trial counsel engaged in ineffective assistance of counsel by failing to call a medical expert. So to the first point, Your Honors, regarding the abuse findings that were made in this case,
So
there's a,
the court can take jurisdiction if abuse is present or if neglect is present, right?
correct.
And we've got a recent case, the initials always get me confused, but if we were to determine that there was neglect, would we need to even reach the question of abuse?
Either would give the court jurisdiction.
In other words, I think we said in a recent case that unless somebody's briefed sort of collateral consequences stemming from the abuse finding, the neglect finding is sufficient.
Correct.
And there hasn't been any effort to sort of make an argument that there's independent collateral consequences that flow from the abuse determination that wouldn't have already flowed from the neglect determination. Is that right?
Well, there is a difference in terms of the kinds of services that parents get when they are adjudicated as abusive versus neglect. So there are consequences. However, in this instance, we indicate that both of these determinations were in error, both the abuse and neglect determinations.
But the difference there inures to the benefit of the parents, right? If there's a neglect determination, they're a more appropriate candidate for services, so forth, than if they're abusive.
Correct.
Well, I'm just thinking through the posture of this case. Like if we were to determine here that the neglect finding was appropriate, we could just stop and we wouldn't need to deal with whether the abuse finding was appropriate, right?
If this court determined that would be the correct response. However, the findings that were made on the record did not meet the clear weight of the evidence that neglect was
Yeah,
actually
let's start,
done.
why don't you start there then?
Absolutely.
Tell me why the neglect determination didn't meet muster.
For sure. So neglect is defined as lack of proper, and the particular definition that this court, or excuse me, that the juvenile court used to determine neglect in this case was lack of proper parental care of a child by reason or fault or habits of the parent, and or failure and refusal of parent, guardian, or custodian to provide proper or necessary subsistence, medical care, or any other necessary care for the child's health, safety, and morals. But there is a threshold legal issue that this juvenile court neglected to address, which is the exception to these neglect findings, which is a healthcare decision, and this is articulated in the statute, a healthcare decision made for a child by the child's parent or guardian unless the state or other party to a proceeding shows by clear and convincing evidence that the healthcare decision is not reasonable and informed. And the most recent case on point with this is In re MS, and in that case, the court found that absent a court's analysis of whether a parent's medical decisions satisfied the reasonable parent standard, the juvenile court's adjudication of neglect is unsustainable. And that's the same error that this juvenile court fell into.
Okay, so my question then is, at the time these children were removed, they were, I think the phrase from one of the medical professionals is severely malnourished. They had diaper rash so bad the wound team needed to be called in. There was just an overall general failure to thrive. Help me understand why there's a medical determination that we have to evaluate. I mean, if these children are malnourished and severely underweight and have care issues that require the intervention of the wound team, isn't that enough right there for a neglected determination?
So firstly, it's important to remember that these children had had an acute medical episode before, at the very beginning of this case, where they had been throwing up quite a bit. There had been a justifiable reason with this acute illness to losing weight. And so by the time the court has a safety plan in place to see that they're steadily gaining weight, we're not talking about, there was no reason for weight loss at any point in time. There were justifiable reasons on the record to see why these children may have lost weight at some point in time. And that really does leave the diaper rash issue and the G-port issue.
So, wait, you're just taking malnutrition and setting it aside? I didn't follow why.
Well, failure to thrive can be a challenging thing to treat for parents. And so, like I had mentioned, the children had had an acute illness. They were working with healthcare providers to address that. And the record indicates that actually the children were not continuing to lose weight, but had stagnant or weight gain in the appointments that they were asked to attend regularly as part of the safety plan. So the malnourishment issue was not emergent at the time of the shelter hearing. There was a safety plan in place to address it. And we didn't have parents that said, there's no problem with these children. We don't see what you're upset about. We had parents that were the people who brought the children to medical professionals in the first place to say, there's an issue. We need help addressing the issue. And then the medical professionals gave them instructions on 24-hour feeds to address the issue of malnourishment. And so the parents were addressing that issue as best as they could.
Okay.
So as to diaper rash issue, and the G-port issue, to diaper rash, it's actually, I'm a parent, I'm assuming some of us are parents as well. To have broken skin with diaper rash is pretty common, actually. And the testimony on the record indicates the wound team was brought in because the skin barrier was broken, but that can be the result of exposure to a certain antibiotic, and we know these children had UTIs at some point in the recent history of the case. It can be caused by allergic reactions to food. It can be caused by allergic reactions to environmental issues or materials in a diaper. And there is indication on the record that right before the children were taken into custody by the division, they observed mom changing the children's diapers. And so then the children were placed in the car for several hours in the custody of DCFS, and at that point, diaper rash was observed. But it's also important to remember that Nurse Meekum saw these children several times in clinic, and since weight gain was the primary concern, we can presume she was removing diapers to get accurate weights on the children, and there's never a mention of problematic persistent diaper rash by Nurse Meekum, who is the medical professional who saw these children more than anybody else. So as I mentioned, without the court making its determination as to whether these parents met the reasonable parent standard, the juvenile court fell into error, and MS demands that decision then has therefore it's infected the court's entire ruling, which forecloses the usual basis for deference to the court's adjudication finding of neglect. If this court is interested in talking about the abuse issues, the 5 instances that were recorded by the juvenile court as instances of abuse we mentioned in our briefing, there was no finding of harm by the juvenile court, meaning that the CT scan, the MRI, the EEG, the blood draw, the catheterization swallow studies or seizure meds, the court did not make any finding that any of those diagnostic tests or treatments caused the children actual harm. The only one that it could point to where it made a finding that could potentially be to harm was regarding the G-tube placements, but it would have been impossible for the parents to have sought placement of the G-tubes for their children without several doctors being party to that decision along the way. Surgeons, this is a major surgical intervention, so the fact that they were able to obtain it with doctors that were working with them in Arizona and Nevada speaks to the fact that it wasn't just the parents' whim, that was a decision that was made on behalf of these children. Further, I think it's interesting that the children had different types of G-tubes. So they were serving presumably different needs that each child had, and that would require a level of sophistication and understanding that the record's pretty clear these parents don't have or the ability to articulate. So to say that it was just based on parents making a request is pretty far-fetched. Additionally, Your Honors, there was ineffective assistance of counsel in this case.
Before you go there, could you just address the issue of the finding that there was harm due to them being left in the pack and plays and therefore not thriving and not becoming mobile?
Absolutely. So one of the difficult things that these parents were confronted with was that they were often required to do opposite things, two things that were directly contradictory. And so the first and foremost concern that had been brought to parents' attention was that their children needed to gain weight, and then their children were placed on 24-hour feeds. And they were under the understanding, based on the instructions from the medical professionals that were treating these children, that that was problem number 1. We need to get these children to gain some weight so that they can then develop other skills. So, they were addressing the most emergent problem that they were given in the way that they found most appropriate. Now, it's another example of how a reasonable efforts assistance might have helped these parents do a better job. They could, if they had any kind of reasonable efforts assistance from the division to find how do we do this simultaneously? How do we keep these children on these 24-hour feeds, which were prescribed by their doctors, but still allow for gaining some mobility? That would have been the kind of reasonable effort that would have been a fair and serious attempt to keep these children in the home.
And when you're talking about reasonable efforts, you're talking about your complaint about what happened at the shelter hearing.
Correct.
Not what happened at the adjudication hearing, correct?
Mm-hmm.
At the adjudication hearing, you're not expecting the court to have made a reasonable efforts finding, right?
The reasonable efforts finding to keep the children in the home was part of the shelter hearing inquiry. But it does lead to the fact that the children were then removed from the home by the time we get to adjudication, and it's part of the remedy that the parents can seek by asking this
So-
court to address both.
Yeah, sort of where I'm going with that is that what do you think the remedy is at this point if we think this is an appeal from an adjudication order, which is sort of the first final order in a juvenile court case. I mean, you
Right.
didn't have an opportunity to appeal
Correct.
the shelter order right out of the chute. You had to wait until the adjudication order to come up and appeal this. So I understand all of that.
Right.
But I guess, help me understand practically speaking, if we find some sort of infirmity with the process at the shelter hearing, what do we do about it now?
This court can remand and ask the juvenile court to conduct the shelter hearing again to determine if reasonable efforts were made or could have been made to keep the children in the home. And there's a possible world in which a court can make a determination that children can stay in the home but still make a finding of abuse or neglect. They just have appropriate services in the home. And then the children aren't subjected to the very real harms of removal. And removal harm exists in every case where children are taken out of their homes. It's not pretend, it's very real. And so when we're asked to weigh these competing interests, one of the reasons that these protective limitations exist in the statute is to make sure that we don't unnecessarily remove children who are attached to their caregivers.
Okay, and in thinking through this, do we look at what's happened since in the case, or do we ignore that? I mean, we try to do these child welfare appeals as fast as we can, but we are not built for speed, as it were, like a trial court can be. And so time has passed and things have happened. And, you know, you're certainly aware of what's happened below, and I've looked. And so we've had a long period of services provided to this family, and there's been a determination made at a permanency hearing that those services haven't done the trick. So in that context, tell me, does that matter?
No.
Does that sort of moot these issues? Does that make it sort of a useless exercise to send it back for a reasonable efforts determination now that a court's already made a much more fulsome reasonable efforts determination?
No, this is the only opportunity that we have to correct the errors that were made at the shelter hearing and at adjudication. And the errors were made. And so this is the only opportunity we have to define case lists to help us not fall into those same errors again. But if this court were to determine that it could go back and have a reasonable efforts finding at a shelter hearing, there is a chance that the children could receive reasonable efforts at home. And the fact that when this case proceeded down the line, that things played out differently, doesn't mean that the correct decision was made early on. Because one of the things that happens once there's an adjudication of abuse or neglect is that parents are viewed very differently. The services that they receive, particularly if abuse is the finding that's made against them, are not as helpful. There is a certain level of, even though this is supposed to be a collaborative process, those relationships tend to deteriorate between the division and the parents at that point in time. And so the only way to kind of check this runaway locomotive that has happened by the wrong decision happening at the adjudication trial is to reverse and have the opportunity to fix that error.
I wanted to clarify, have the parents received services since the children have been removed from
They
their
did,
home?
yeah, they did, but that was not
What-
for.
What services have the parents received after removal?
So, because the record doesn't go into great detail on that, I'm not as informed. I could happily look into the issue for the court if they would like. I do know that there were psychological evaluations that were completed and that parents received therapeutic treatment based on the results of those psychological evaluations on behalf of the parents. And I'm presuming other appropriate, I mean, the finding in the adjudication order was that, you know, parents would receive a child and family plan, and that it probably addressed a lot of the needs that had by that time been discovered. But again, disposition's pretty far down the line. And I think one of the things that I found the most unfair, and I apologize, I am out of time, I don't know,
Please continue.
Just fine.
to the reasonable efforts issue, when the children were removed from parents' care and they were placed with foster families, immediately, the types of services that the foster parents were able to receive included extensive education at the hospital as to the children's medical needs and how to properly feed and treat them, feeding tube instruction, healthcare nursing visits, and in-home healthcare, medical experts that came into their homes to help appropriately treat the children and help them gain weight, access to a 24-hour hotline to answer their medical questions, referrals to Shriners Hospital and other physical therapies, as well as full access to WIC and Medicaid, and that's record 836 and 9.
So you're saying that those services might be different than what the parents were receiving during the pendency of the case because the children were with the foster parents?
Correct. And
So
if-
the parents were receiving services, just maybe not those services?
Correct. And if we had just put those reasonable efforts into place and not removed the children at shelter, there's no telling in all likelihood, because the record indicates that once the children received these particular therapeutic assistances, they thrived. And so they could have thrived in their parents' care with these same services that addressed their very particular needs. And there's no way that we can know that now because the determination, instead of this potentially being a medical treatment case, these were laid at the parents' feet unnecessarily.
Yeah, and there's no way to know that now is an interesting comment, given that you're asking us to send it back for essentially a redo of the shelter hearing,
I should rephrase that.
given all the water
Yeah.
that's under the bridge now.
Correct.
So I'm just trying to envision what that redo shelter hearing is gonna look like, given that the court's now already held a permanency hearing in this very case. So we send it back now, there's a primary permanency goal that's no longer reunification in the case. And we say to the court, okay, hold a new shelter hearing. Tell me what you think that shelter hearing looks like.
I'm interested to know myself. I think. But the problem is, we never get at solving this problem with our shelter hearings when reasonable efforts aren't found if we don't do that precise thing. If we don't have a shelter hearing, and honestly, at this point in time, what probably makes the most sense, we have INRI ZCW that talks about when we go back to make determinations that we do them in the present tense. So it probably makes the most sense for this to be a present tense evaluation as well. Are there reasonable efforts at this point in time with how the facts exist and what condition we find the children and the parents in, that at present time we could have, are there reasonable efforts we can engage in now that would allow the children to
Yeah,
stay?
so you think, I think that's probably right. We would have to do a present tense evaluation at the remanded shelter hearing. And the question would be, if we put the kids back in the home now, are there services that we could afford the parents that would allow that to succeed and be in the best interest of the kids? Or I guess I don't know exactly how that
Right.
plays out. That's what you think would happen then?
I think that's what makes the most sense, and it might be a lot easier determination to make at this point, since there's more time, the court has the virtue of more information, but this court made that determination a lot sooner, improperly so, without finding if, at the point in time that it made the determination, if there were reasonable efforts that could keep the children in the home. But we're trying to correct the process. The statute says what it says, and it has a demand that if this is not the first interaction with a family, there has to be a finding about reasonable efforts, and that's just has to be corrected.
Okay, all right, thank you, Ms. Norman.
May it please the court, Martha Pierce, attorney guardian ad litem. I want to begin with the last thing that she said, that the statute says if it's not the first encounter, then you have to make a finding of reasonable efforts. That's not what subsection 11 says. Subsection 11 says if it's the first encounter with the division, then you have to make this finding. They're trying to fit something into there by negative implication, and that's simply not the case. The finding, the statutes in 83-301 and 82A both talk about what the division's duties are. And it says the division and later the court has to determine whether reasonable services can keep the child in the home. And that's what the court found, that they did receive some services. They weren't enough to keep the child in the home. It's very significant that the caseworker.
Tell me where the court said that, because I mean, the court made a comment about, hey, I'm not gonna leave these kids in this home unless and until there's a plan in place. The
Right.
court did say, is that what you're referring to?
And also when the court said things are gonna get worse and worse and worse. So, and I can't remember if the court talked about the formula, the visits, the pack and place that they bought, all the assistance they did to get them on WIC, but the record shows all kinds of services that were provided. But the difference was that as soon as the division determined that these services really depend on the parents being able to cooperate with us, the parents being able to tell us the truth, us being on the same page about what the children need, that's when the caseworker said, safe with a plan, safe without a plan, because you could not rely on that. And
Well, I guess I'm just interested, you seem to, I think your argument is that the court did do what the statute required on the
Exactly,
record.
yes.
And I'm pushing back on that because I'm wondering where, the statute requires the court to make a determination on the record, first about reasonable efforts, whether they were made before removal. And second, there's a second part to this, and that's what these guys are stressing. The second part is the court has to make a determination on the record as to whether there are available services that would prevent the need for continued removal. And I guess I'd love for you to point me to a place in the record where the court made
I
that
would look at the
determination
court's-
on the record.
I'm sorry, I would look at the court's oral findings on that. And as we're talking about that, then please let me talk about preservation.
Where, the oral findings where?
Well, the oral findings, when the court said, if we keep the child in here, it's gonna get worse and worse and worse, which means you can't provide reasonable services to this household without endangering the children. But first, I think I need to address, can this court even reach the issue of lack of findings? Because under NRA KF, it says if the findings are insufficient to provide for meaningful appeal, the burden is on the appellant to preserve that, and that applies to child welfare cases as well. And NRA ATIG reaffirmed that it's a burden on them to do that. Now, they cited to the health case to say, well, if the court made a finding, but this is about findings, so the health case doesn't apply. And the health case is very problematic. It was a 2015 case from the Supreme Court. The Supreme Court has backed away from it, has never relied on it in terms of preservation, while this court has. Since the time of the health case in 2017, the Supreme Court issued both the Bauman versus Kroger case and the State v. Johnston case that said that whenever you have, particularly in cases where you have to develop a factual predicate, then it's all the more important that the preservation rule be in place. So the Supreme Court has actually built up its preservation doctrine in those two cases. And I would submit that they have not preserved this claim. Now, let me talk about, she said that the only opportunity to challenge the shelter order is an appeal from adjudication. But that is true and yet not quite true, because the nature of an interim order means that the court can always review and revise it at any moment until you get to the final order. And the way the child welfare law is structured, that at virtually every hearing, the court has to make a finding of reasonable efforts. And implicit in that finding is, can the child return home with reasonable efforts? And so there's numerous opportunities for the parents to come back and request different kinds of services. And while I'm talking about that, I need to correct a misstatement, that she was saying that there's a difference, that somehow the services are different if it's dependency, if it's neglect, if it's abuse. That's not true. Under 80-3-307, the services that are available are based on the findings and not on the category of adjudication. The only category of adjudication that requires a different kind of services or no services at all is not abuse versus neglect versus dependency. It's neglect and abuse versus severe neglect and abuse. If it's categorized as severe, then that's a different category, and then then there's a presumption against reunification. So I think that's different. The other thing I wanted to say is that feeding your child is not a healthcare decision. The court made very clear findings about each child, that failure to thrive, non-organic failure to thrive.
So you think the condition of the children at removal is enough to justify a neglect determination?
Absolutely. Under the criminal code, failure to thrive is a severe form. She also said that the children were not harmed. Under the criminal code, failure to thrive is a severe form of physical injury. And this court in NRA CMH referred to the definitions in the criminal code. And under the juvenile code, failure to thrive is a severe form of abuse or neglect. So I think if you only look at failure to thrive, then you're there. You're there in terms of removal, you're there in terms of the
Seems like
adjudication.
part of what's driving the complaints from the parent side is that the DCFS and the medical professionals were sort of aware of the failure to thrive and the malnutrition for several months, yet waited until November to effectuate the removal. Is that a problem, or does that matter?
Well, it is because the issue is whether or not it's non-organic. And so it did take that whole team of doctors reviewing 6,000 pages to find out really what is going on. And in the meantime, you have all these frequent visits from the caseworker, helping them get set up for the WIC, helping them get the birth certificates, all of that, providing things that they needed. Because at that point, she thought the parents were cooperative and that the parents were not delusional. But later on, after reviewing all of those records, and I think in my mind, the strongest example of how delusional they are is when the mother was pointing to a scar, the spina bifida scar that nobody could see, but she could see it. And that tells you so much about how it is to work with these parents. But I think it took that team of medical professionals looking at the 6,000 pages and doing their own testing to find out this is non-organic non-organic failure to thrive.
Did the court make a finding that it was non-organic?
I believe it did. I think it did.
Do you know
Oh.
where to point me to that? I'm sorry, I should probably
In the oral
know.
findings, the court several times referred to how it's up to the parent to, this is the best, page 63 of the shelter hearing transcript. He says, ultimately, it's up to the parents to identify that and care for these children, and the children were not thriving. Unfortunately, they just were not. So the court's saying you don't have to be a sophisticated medical professional, but you do have to see that my child needs something, and to get that medical attention, and in this case, to provide an accurate history, and to do what the doctors say. And they found out that these parents just aren't capable of doing that if they are seeing things that nobody else can see.
I suspect that the parents would respond that they had G tubes and were feeding the children through those tubes, and yet there was still failure to thrive. And so it does seem important to me that there might ought to be a finding that the failure to thrive is due to action or non-action by the parent. That failure to thrive
Well, you still,
isn't itself neglect if the parents didn't cause it, any more than a broken arm is neglect if the parents didn't cause it.
but you still, like, they have a G tube, but you still have to put in sufficient formula and sufficient
And so
calories.
that's why I'm asking, is there a finding that the parents were not doing that?
That they weren't putting it, well, I think several times in the findings, and I'll give this court a 24J notice and point that out, but I remember the court saying that we've got non-organic failure to thrive, they're not getting enough nutrition. And I think and it's obvious that as soon as someone else was in charge of the G tubes, the children just chunked right up.
So let me ask you, I know your time's up, but you mentioned earlier that you thought that the remedy for a problem at the shelter hearing is to, bring up a reasonable efforts or something, because, you said there are different points in
Exactly.
time when somebody can bring up reasonable efforts during the pendency of the case. I understand that. But it's true, isn't it, that the first time they could bring a shelter hearing problem to us is, at least as of right, I guess they could try,
Yeah,
I guess
the
they could
first
try,
time-
they could try Rule 5.
Exactly.
But the first time is the way these guys did it, which is after the adjudication order is into place, that's a final order, then you can appeal whatever's behind that that's non-final, right?
That's true. That's
Okay,
true.
so.
But then this court would also not only look at the shelter hearing, because now we're at a final order, the court would look at all these other interim findings of reasonable efforts and what has happened.
Yeah, we
Be-
can, for
yeah,
sure.
yeah.
And so my question, I guess, is, so now that that's in front of us and it's appealable and they brought it to us in a proper way, if we see a problem that occurred at the shelter hearing, what do we do about it? Like, what does a remedy look like now that all this water's under the bridge? Like, my question to Ms. Norman was, well, what does a remanded shelter hearing even look like? And I'd like your thoughts on that, too.
Well, I don't think you'd ever remand the shelter hearing because it's an interim order. You have to remand the adjudication. That's what you have to remand. You can't say, I want to redo on this, because the court at every single hearing has to make a reasonable efforts finding.
Well, what if we find that the problem wasn't the reasonable efforts part of the statutory requirement, but the problem that, what if we find that the problem was the court didn't really make a determination about whether at the point of removal there was available services that would have prevented the need for continued removal?
Well, then I think,
How do
but
we cure that? If we find that problem, how do we cure
if you
it?
find that problem, then that also is wound up in the adjudication order, because then the parents would have attended the child and family team meeting under 83-307. The court would have approved the service plan. The parents had an opportunity to say, this is what should be in the service plan, and if you send the kids home with these services, we can do it. So you have to look at it at that point in time. You can't say what was happening then. You have to look at the adjudication order itself, because the situation keeps evolving. It's a very fluid situation. And there's several opportunities for the court to change the services. Now that they've got counsel, the counsel can ask for different kinds of services. They can ask to have the child come back, be returned. And these review hearings are on demand under Rule 47. So
To me,
there's,
it sounds, from what you're saying, and I just need to be educated.
yeah.
That the shelter hearing is not really ever reviewable on appeal as a standalone decision.
It's not. And the elements in the shelter hearing are reviewed and revised all the time throughout the history of the case. And so in some ways, it's more important what happens after the parents get counsel and they go to these meetings, because then they have lots of opportunities to specifically ask for
Yeah,
different
so it
kinds of
sounds
services.
like what you're saying is that, yeah, there might have, even assuming there was a problem at the shelter hearing, it's sort of mooted by subsequent events? Is that the way you'd put it?
In some ways it is, because it is a fluid situation. And as you mentioned, to go back to that point in time and say, let's look at back then, that's not very helpful because it's such a fluid situation. And so what did they do to remedy that? What services did they ask for? What services did the judge suggest? All the different times the judge had an opportunity to say, yeah, I like this set of services, this makes sense to me. Or did the parents object and say, no, these aren't enough, we really need this and this and this. So you get a more fulsome record by looking at the total record up to the time of whatever it is, final order that you're reviewing. And you've even looked at the it sounds like you've even looked at the permanency hearing. And the permanency hearing, the single question is, can the child safely return home with or without services? And so the court, again, made those findings.
Yeah, that was my question to Ms. Norman, is the court at that point is really dealing with the reasonable efforts question in a much more fulsome way, right? Has reasonable efforts, it's been, what, a year now? Reasonable efforts.
Right.
Or services have been provided, maybe not the same kinds of services that they're talking about, but the determination's made that services have been provided, things aren't working out, and I don't think the kids can be safely returned to the home. And that's the finding that was made at the permanency hearing, and I take it you think that matters.
Not an appeal from an adjudication, you really can't look at that, but that's just an illustration. But
Well, I guess I'm wondering why, if we're looking at subsequent events mooting things, we look at, that's one context in which the Court of Appeals does look at subsequent
Oh,
events.
you're correct.
If subsequent events have come along and mooted the question.
Subsequent events couldn't-
Or like, the question with regard to mootness is, well, what sort of remedy can be provided? How would our review of the shelter hearing really affect the rights of the parties at this point? In those kinds of questions,
you can look
can't
at-
we look at stuff that's happened since?
Yeah, in terms of the remedy, you definitely can, in terms of what's available for challenge from the perspective of the appellant. No, they're limited to that. But in terms of the remedy and whether it's moot, you definitely can look at subsequent events. That happens all the time.
Yeah, that's kind of that was
Yeah.
my impression of it, and I
No.
just wondered if you agreed with me on that.
See, want to go back to my other question. Where the shelter decision is not an immediately appealable decision,
Right.
and then things become fluid after that, in that fluidity, there is a decision that the children have been removed from the home. And so it seems like what you're saying in a way is, unless at each hearing you say, hey, I want the kids back and I want services with them in the home, then you're not really preserving that shelter decision. That each time you need to start the discussion with, Your Honor, you got the initial decision wrong, I want them back and I want services in the home. And the court will probably say that decision's already been made. Now let's talk about what we're doing now. But that unless the parents say that through that fluid stream of events, they really can't come to us later when the shelter decision is appealable
Well, generally,
and
they're
say
not
anything.
saying,
Does that make sense?
generally, they're not, that's how child welfare cases are very different than other cases, because generally, you're not saying, Your Honor, you got it wrong, but more facts have emerged. You've got the psychological, so you're aware of more services that could be available. And when you read the transcripts of reviews, that's always, you look at the psychologicals, you look at what you know now, and you say, oh, if we only had this, if we only had a peer parent, if we had this or that or the other. And a good defense attorney is always asking for those kinds of things. And the service plan is always, you're adding to it, you're playing around with it because the facts are emerging.
I guess what troubles me a little bit is it then feels like that there never really is going to be an opportunity for a meaningful appeal of the initial shelter decision. Is that kind of where we're at, if we go with what you're saying?
Maybe not, but it's very common for the judge to return the child at the shelter hearing, to return the child at a subsequent hearing, because you find out that there are certain services you can put in place. And so it doesn't make sense to make the shelter hearing a final appealable order, because things are so fluid and the child really can return, and you have more time to be more deliberate about it. The shelter hearing always takes place at a time of emergency, when there's limited facts known to everybody, and the court has to make these findings, and that's why it's at a lower standard of proof. Right, okay, well, I didn't want to take up your time, but thank you.
Thank you, Ms. Pierce. Mr. Peterson, your turn.
May it please the court, John Peterson, Assistant Attorney General on behalf of the state. I guess I'll start where we left off with the shelter. And I have a hard time envisioning, a case where there really is going to be much of a remedy for assuming that there was any kind of error. I mean, because really a shelter hearing is really the ultimate kind of point in time determination. What were the circumstances? Is this child at risk? Are there services in play? What can we do? You can't, I mean, to say to do a redo, you can't go back, I mean, because maybe one of the parents died. You know, maybe something changed. I mean, you've got to, I mean, as this court ruled before, all child welfare determinations have to be present sense. I mean, that they just, there's no other way to do
Yeah,
it.
so what's your view on whether we can consider what the court just found recently at the permanency hearing? In terms of figuring out what any remedy might be for a problem at the shelter hearing?
I mean, I think, I mean, yeah, because I don't, I mean, really the permanency hearing is one thing, but the adjudication too. I mean, I don't see a situation where you could make an adjudication of abuse and neglect and that the children need to remain in state custody and then go back and say, but the shelter hearing was wrong and you should have returned them at that time. I mean, because the circumstances of this case didn't change, you know, dramatic. I mean, the problem with this, with medical abuse cases is they're sui generis. Even in a case with like severe addiction, all kinds of problems, you generally assume that a parent is looking out for their child's best interest and doing things that are going to help their child to the best of their ability. I mean, with medical abuse, that assumption goes out the window, and you now don't really know what parents might do. I mean, and that's why the idea of like you're returning the children to shelter was, I mean, the court, you know, made a finding. You had to look at the transcript at 64, but the court said, you know, if there are services in place that can make these children safe, I'd consider returning them home, but there are nothing in place at this time. I mean, a good example
Yeah,
of
but
what.
that's the problem, right? He's supposed to evaluate whether that's their complaint exactly, is at that moment in time, he can't just say, well, I'm not gonna leave him I'm not gonna leave him there unless there's a plan in place. What they're saying is he's supposed to evaluate at that point in time, well, what should the plan look like? And if I put that plan in place tomorrow, can I leave the children in the home? And they're saying he didn't go through that exercise.
Yeah, I mean, to my way of thinking, the judge, I mean, did go through the exercise. I mean, basically, just, I mean, the problem with these parents is, I mean, you see Dr. Darrow, you know, canceled the CT scan, and the mom still went ahead and ran out and got the CT. I mean, you can't leave a children with parent who is perpetrating medical abuse and consider they're going to be safe. I mean, because they're not doing things in the child's best interest. They could run out, they could take a child to another, you know, provider without a background and start doing things. They could catheterize the child again, and necessarily there's these things that are, I mean, that's why, I mean, you talked about why did things change? And we were working with them, there's a little failure of 5, it's not going that great, then all of a sudden, there's a sea change. Because they diagnosed, Nurse Solomon diagnosed medical child abuse, and they're like, you know, they aren't doing what a parent's supposed to do. They're not doing things, they're doing things that are medically harmful to their children. And I mean, and what services can you put in place that's gonna keep a child from going to some new provider and perpetuating the false narrative is, you know, the words that the juvenile court use. And that's an important, you know, this idea of perpetuating a false narrative. Doctors assume that when a parent comes in and tells them their child has a G-tube because of such and such and such, they don't look at them and go say, you're lying, that's clearly wrong.
Well, maybe there wasn't any services that could have been put into place at that point in time that could have kept the children in the home. But I think the complaint here is the court didn't really go through the exercise and make that finding on the record, make that determination on the record as the statute requires.
Yeah.
And you don't see that as a problem?
I mean, I don't think that maybe the court could have been clearer and that could have made it clear, I don't find their services in place, but I think that the court's actual, like, the finding he made on the record, or is that the court didn't believe that there were services that would keep these children safe. And so, I mean, I think that the court felt it was going analytically through that process, and I also think, but then later
Well,
on.
by saying I'm not gonna leave these kids in the home until there's a plan in place, sort of the negative implication of that is, well, if there was a plan in place, I could leave them in the home, which leads you to believe that maybe he thought there was some services that could have been provided that could have kept the children in the home, no?
I mean, I think the court's finding was not aware of anything, you know, off the top of my head, you know, they could work at this point, but, you know, if you can formulate some kind of plan, you know, I'd be happy to get these children back in the home as soon as I can, were there something that we could do that would make that a safe situation. And I don't think there's anybody at that point in time saying, here's a plan where we can make these children safe. Here and right now, the children that we just removed, these children who experience, you know, substantial medical neglect. I mean, who showed up to the hospital with like open sores and 3 diapers, inflamed G-tubes. They were in sorry shape. I mean, and I don't see any juvenile court judge in the world would have put these children back in the home at that point in time. I mean, services.
So I take it your position is that the condition of the children at removal was enough to support a neglect finding?
Oh, yes, definitely. I think quite easily. I mean, it's the tip of the iceberg with these children's care, but that's just a snapshot in time that, I mean, the basic, the ongoing problem with this failure to thrive, they have G tubes. You can literally put nutrients into their stomachs and they're still malnourished. I mean, these children are not being cared for. And it became clear how badly they were not being cared for when they have multiple layers of soiled diapers and wounds. I mean, these are not just like a little bit of diaper rash. This requires a referral to a wound team. I mean, that's fairly significant. An inflamed G tube, that's a direct line into the urine internal body. It's dangerous. That's something that needs to be cared for. So, but I would also say that even were this court to find that maybe there's a missing finding that the shelter findings could have been better, we had a full adjudication. We have a full determination. Again, like when the kids still aren't going back home. So the idea that we're going back and redo the shelter hearing and say, well, at the time of the shelter, maybe they could have gotten home, even though they can't go home now, and even though we've been, like you said, we've been up to a permanency hearing, still can't go home, things still aren't going well. I mean, it defies logic to say how you can go back and pull the legs out off the table after the fact. I mean, at this court, I think it's possible that this court can reach shelter issues, under some of the exceptions to the mootness doctrine. If the court is concerned about how the judge analyzed things, I mean, I think the court could find, these findings are, capable of repetition yet evading review. I mean, the shelter hearing seems like the poster child for that sort of analysis, because you're always going to have an adjudication, almost immediately following it. And maybe the court wants to, to provide some guidance about how the juvenile court should be doing things, but the idea that we could go back and just kind of have a new point in time snapshot of this case and start over. I mean, unless this court were to, undermine the adjudication, find there's no basis for juvenile court jurisdiction, then, I mean, maybe the whole case could start again, but I find that to be unlikely under the facts of the case. I mean, the basic facts of removal were enough really to support juvenile court jurisdiction without even getting into more complicated issues of medical neglect. I was just going to, I don't know that the court made a specific finding, Judge Luthi, about the non-organic nature of the child's thing, but there definitely, Dr. Russell, record at 1059, definitely one of her findings is, these things, with the exception of, I think, MJ's club feet and the genetic thing, which is not the George syndrome, Dr. Russell did find that the children's problems were not organic, they are environmental problems caused by ongoing neglect and abuse. And I see I have used my time if there's no further questions.
I don't see any. Mr. Peterson, thank you
very
for
much,
your
Your
argument.
Thank you, Honors. Kirsten Norman. One of the things we've been talking about a lot is what does the remedy look like? What does that hearing look like? Potentially we have another shelter hearing because of the error that took place. It would be a present tense analysis for a shelter hearing, specifically addressing how parents can continue the current interventions that are working to help these children thrive and do them in the home. And the problem with looking beyond the record as it was presented to this court and saying what happened further down the road is that it makes the right to appeal illusory. If any time we can point to a shelter, or to a permanency hearing that happens further down the road and say no harm, no foul, then we never have an opportunity to correct these very real errors that happened earlier in the case. And for parents that are in these situations, it's these processes that protect their constitutional rights. And so it's very important that we adhere to them appropriately. And where a statute has a requirement and where a court has failed to meet that requirement entirely, that we remedy that part of the decision and remand so that the juvenile court has the opportunity to do that. And I think that an example of a similar situation in a criminal context would be when we have information further down the road. In a criminal case, if a defendant loses a motion to suppress and then is convicted at trial, we can still reach back to that earlier motion because it tainted the entire case. And that's often what happens with these types of cases. As defense counsel, we see it all the time. That initial removal happens and these cases kind of become a self-fulfilling prophecy. The parents don't have control over their children anymore. They aren't in their everyday life. Their visits are limited to maybe once a week supervised. And everything starts to deteriorate, even a lot of times with efforts that are made on behalf of the division. And that's the problem that we're trying to remedy. And as you've noted correctly, this is our first opportunity to do so, our only opportunity to do so. And so it's important for us to remedy this error where the court entirely neglected a analysis that it was obligated to engage in the statute. And it's also important to remember that the reasonable efforts determination that the court makes at shelter is very different from the reasonable efforts determination that it makes along the road. So the determinations about reasonable efforts that are made at subsequent review hearings go to whether the division is fulfilling their statutory obligation to provide reasonable efforts, is what they're doing like on an ongoing basis, meeting their obligation. The question about reasonable efforts at the shelter hearing is, are there reasonable efforts that could keep children in the home?
Yeah, I guess I don't see that it's as different as you do. Help me understand that. So the reasonable efforts determinations that happen during the pendency of the case and ultimately the final one at the permanency hearing, they go to whether the DCFS has made reasonable efforts to facilitate reunification, which is basically this sort of flip side of the same inquiry. Can we keep these, are there reasonable efforts that can be had here at the removal stage that can keep this family together? So it's keep together, reunify, those are kind of, it's the same goal. Are there efforts that could be made to achieve that goal? I guess I see them as not quite so different as you. Do you have thoughts on that?
There are instances in juvenile court that we have seen where a juvenile court can change it, they've made a finding of disposition as to what's appropriate, right, for the outcome of the child, and they can change it. So it would be akin to that. It would be saying, we've looked now at what kind of services do work to help these children thrive. We've never offered parents these same level of services in the home to see if they could stay home with those services. And so we can make that attempt. And because we're asking the court to go back and make a present tense decision, it might be a very easy decision for the court to make, but it still has to do it properly. It still has to adhere to the processes that are outlined in statute in order for parents' rights to be properly protected, and in order for the integrity of this family to be properly protected.
Seems to me that for your analogy to the criminal law to work, you'd have to do away with the idea of making a present tense determination, because in criminal law, when we down the road figure out that something should have been suppressed long ago, we don't then make a present tense determination and say, well, how's the criminal case gone since then? Do you agree that we're talking as though we all agree that it should be a present tense evaluation, and our case law seems to suggest that, but do you have a comment on that observation?
Any analogy I'm going to make to criminal law is going to be imperfect. I mean, potentially another example in that realm, and I'm not a criminal law attorney. I'm doing the best I can to draw these analogies. Would be like bail hearings are final. We've already determined, guilt, and they're appealable by statute. This is a similar endeavor that's appealable by statute. It indicates in the record that this is a statutory requirement.
I was wondering about another criminal law analogy when
Okay.
you shared your, the fact that we have a conviction does not undo an error that was made in a motion to suppress. Point taken. I was thinking the more apt analogy might be, you've got a complaint that there was a bind over in a flawed preliminary hearing. This was not really probable cause. We got a lot of cases that will say, never mind all that, because that's a lower evidentiary standard. Meanwhile, now we have a jury who has convicted the defendant of the crime by a beyond a reasonable doubt standard. So the fact that maybe there wasn't technically a good showing of probable cause at an earlier point in time just doesn't matter. It strikes me that that might be similar here. There were some procedural failures at the shelter hearing. It seems like, by my analogy, we would say, but never mind all that. We've since advanced to a more fulsome, to borrow Judge Harris's term, a more fulsome adjudication, and made a permanency determination. So maybe to Mr. Peterson's point, if we see some problems in the shelter hearing, we note those for education and clarification for juvenile court judges doing their work going forward. But it seems like, again, borrowing Judge Harris's phrase, all the water under the bridge since, it's very problematic to try and go back and redo a shelter hearing where so much has happened since, and now we have the more fulsome determination in the permanency context.
I can see your point in terms of what kind of remedy we're looking at it here. But again, the process really matters here. And in this case in particular, we're also arguing that the abuse and neglect findings were inappropriate. There wasn't clear and convincing evidence that either of those were actually true. And so all of these are mistakes.
Yeah, if
that
that's
we did.
true, then it
Right.
takes care of the whole rest of the case, because
Correct.
there was never any jurisdiction to
Yes.
do anything, right?
But I wish that, noting a problem in education in the future solved all of our problems, but honestly, case law really gets us there. And making sure that we understand that these statutory requirements are enforceable and they have teeth. And that when we take an appeal from a shelter hearing because there was a problem, that there's a remedy for a family.
May I ask one question on the adjudication part, which may be not the most appropriate for your reply time, but I think we've got time if we need to get a response. Of all of those, of the abuse and neglect findings, I think that the one in my mind that is most problematic for you is the finding that parents consistently, over an extended period of time, provided false, misleading, or exaggerated information to medical professionals that resulted in unnecessary, harmful procedures being done to the children, and that being supportive of a neglect finding. Can you address that finding in particular, please?
So ultimately, to find that neglect provision applies, there has to be clear and convincing evidence on the record of that, and that's what the court points to as is, I think that potentially these parents lied. But in the order itself, record page 331, the court makes a finding that mom is credible. And so those two things directly controvert each other, and that can't be clear and convincing evidence.
Thank you.
Okay,
you, Your Honor.
thank you, Ms. Norman. Thank you, Ms. Pierce. Mr. Peterson, we appreciate the arguments that were made today. Interesting case. We'll take it under advisement, as we almost always do, and get you a decision as soon as we're able to do so. Thank you. Court will be in recess.
All rise.